Hello, my name is Leslie Reyes. I'm an immigration attorney here to answer your questions about immigration or about criminal law. So I wanted to start with some breaking news. As we know, immigration, some just news of immigration in general. So as we know, I believe I just saw that the Laken Riley Act is about to be, they're calling for a vote on it in the Senate today. So what that means is that if they have a, if they get the majority, they're going to be able to have this signed by the president. I think they will probably wait until at least President Trump will be president, so then that way he will automatically sign it. And so what this law does is that it targets people who have been arrested for a crime, who have been charged with a crime, or have been convicted of a crime. Now, the reason why that this is such a problem, and a problem that we see ourselves here as immigration attorneys, is because right now the law is if you've been convicted of a serious crime, convicted of a serious or violent crime, then you will be able to, then you are going to be detained. And you may not have a bond depending on how serious your case is. But the Laken Riley Act, what it's doing now is that it is also saying it doesn't matter if you're innocent of your crimes that you committed, or if you have, or if you were found innocent of your crimes. It does not matter. That as long as you were arrested or you were charged, you will be detained by immigration and be detained indefinitely without a bond. This is a violation of constitutional rights, which is why us as immigration attorneys are advocates against the Laken Riley Act. So if you have an arrest, a conviction, just be prepared. Like this is what's going to happen. And the Riley Act is only saying that it's only for theft crimes, shoplifting, any sort of theft, larceny, burglary. But under the Trump administration, what we saw last time with his executive order and his enforcement policies is that it included anyone, any crime, for any crime that you've been arrested for, charged for, or convicted for, you are being detained by immigration. But this act will say that you are not allowed to even request a bond. So many people who have legal status here, like DACA recipients, TPS recipients, asylum recipients, are all going to potentially have this problem if they've ever been arrested or charged or convicted of a crime. So if you have any questions, please give us a call at 323-553-1541. So I am here to also answer any questions related to immigration. If you have any questions related to immigration, I am more than happy to answer them for you. Critical Thinker, hi, thank you for being here with us. And so I wanted to also give information of what we know of what's going on. So we have raids that right now are also going on. And in these raids, we're also seeing that there are targeting Latinos who happen to look like immigrants. So I just wanted to reiterate your rights that you have, despite the fact that you are undocumented. Contrary to popular belief, you do have rights. Our Constitution, and especially our Fourth Amendment and 14th Amendment, are not bound to only the U.S. citizens. They are bound to any person here in this country. So that's why it's important to also know your rights as an immigrant, because it may help prevent your deportation. So if you are detained, you have a right to remain silent. Please do not provide any information that will let them know for sure that you are undocumented. Do not have any foreign documents with you unless they are valid documents, unless if it's a valid visa, for example, valid work permit. Do not have anything that's going to be related to your status or to show that you are a foreigner. You don't want to give them more proof that you do not belong here. Okay, so do not be having any of those documents in place. Second, if you are detained, usually they need an arrest warrant. So make sure they have an arrest warrant for your arrest, and that you are getting and that the arrest warrant is signed by a judge. It has to be signed by a judge. It's especially important if they're coming to your house and they come knocking. They can't enter your house without an arrest warrant, and they have to show you, if you demand one, that they have one, and it has to be signed by a judge. So if at the end of the day they have this and they have means to detain you, you ask to see a judge. Do not be scared by their scare tactics of saying that, oh, well, if you if you don't sign this document, we are going to detain you. You're going to be detained for a very long time. Do not be discouraged by this, because it is a scare tactic. It is their way of getting you to sign a document saying that you are willingly wanting to be deported and that you're going to do a voluntary return. But many times it's not a voluntary departure. It could be a deportation order. So you don't want to sign anything. Do not be scared to exercise your rights, because that is what's going to frustrate the system, is if you exercise your rights. By exercising your rights, it's going to show how it's impossible for Donald Trump to just deport everybody, because people have rights. We have rights. We have a constitution that says you have these rights. And so far, hopefully we have, the courts in place and attorneys in place who are willing to fight for those rights also. So that's something that you can do. And you have a right to a judge. The only time you may not have a right to see a judge is if you already have a deportation order. If you already have a deportation order, it's a lot harder for ICE officers to say, oh yeah, sure, we'll give you we'll give you a chance with the judge, because you already have a deportation order. So, but from their point of view, they don't have to. They could just deport you. And if you're from Mexico and you have a deportation order, it's so easy for them to put you on a bus and boot you out of the country. Any other country, they have to detain you. They're going to have to detain you, and they're going to also have to, make sure you have a passport, because you're going to need a passport to fly home. Mexico, easy peasy, throw you on a bus and get deported. Okay, so if you have any questions regarding immigration, please give us a call at 323-553-1541. So many questions that I have been seeing lately is, what happens if, I have a case in process? Does that prevent me from being able to, does that prevent my deportation? So it's a little bit more complicated with that. And with immigration, if you already have something in place, I do believe that it will stop your deportation. Can they still detain you? Absolutely. They could absolutely still detain you regardless if you have a process in or not. So what you want to, you want to make sure you have those receipts, that you have a case pending, that you want to have those in place. And by having those in place, you give a little bit of assertion to the ICE officer that you have something in place. Now, it varies from state and state on how these officers are. It also varies in the officer on how, unfortunately, racist they are, because some, if they see that you have a case, they may not care. They may say, okay, fine, we're going to release you, and you're going to have to do ICE check-ins. Fine. Some other ones may not give you that flexibility, and may put you in detention, and you may have to have a bond and then move forward in that sense. So yes, a receipt can prevent a deportation. It may not prevent a detention. So just, make sure you at least have those documents in place. Always have the phone number of your attorney also, so that they can help you, and or at least your family have a phone number of an attorney, so that they are ready and able to help you. Okay, now if for some reason you have not started your case yet, it could be, I understand, financial reasons. Maybe you're scared to start because of the new administration that's coming on. And that's perfectly okay. So I always say it's never too late to get your case started. President Trump is not going to take away avenues to fix your status. He's not going to take away family petitions. He's not going to take away VAWA. He's not going to take away T visas or U visas. He's not going to take away these things, but the only thing he can control is how quickly these cases can be approved and the level of scrutiny in that they're going to be approved. Okay, they could go through a fine-tooth comb and nail to see every single little thing in your history, to see any possible way to try to prevent you from from approving your case. But he can't change the law. He can't change the law without Congress. And I don't think Congress is going to start, passing laws that are going to say, hey, we're going to take away all these types of relief. It wouldn't make any sense. So you guys have that. So if you have any questions, please give us a call, 323-553-1541. If you are here in our live, we are also answering your questions. So if you have any questions related to immigration, any questions at all, please let us know, and I'll be happy to answer them while we're here live. A lot of questions that I receive is, what happens if I have multiple entries, or if I have a deportation order. And what happens with that is there are 3 ways that you could actually fix your status, even though you have a deportation order, even though you have multiple entries. And the way that you could fix your status is by, under the U visa. A U visa is for anyone who has been a victim of a crime. And if you've been a victim of a crime, they will allow you to, if you report it, then you may be able to qualify. It's a long process. So right there, it'll be a little bit difficult, but you would be able to qualify. And it would definitely protect you from deportation. So if you're able for a T visa, have you ever suffered any labor abuses, not paying your overtime, poor working conditions, maybe they've threatened you with immigration before if you're not doing your job, all of that is also a way to fix your status. It works almost the same as a T visa, but it's a lot faster. So that's another avenue that you'd be able to fix your status. Another way that you can fix your status is with VAWA. So if you've been a victim of abuse or a victim of mistreatment by your U.S. citizen spouse or resident, or your U.S. citizen child over 21 years of age, you may be able to qualify. Now, the only thing with the VAWA is that it won't automatically forgive a permanent bar, unless if you can demonstrate that the reason why you have that permanent bar is because of the abuse, is a result of the abuse that you've suffered. So you'd have to tie in those 2 in order to have it forgiven and be able to have your green card. If you think you qualify for any of these 3 reasons, please let us know at 323-553-1541. Elda, good morning. ¿Qué pasó con TikTok? You're not live today. We are live in Spanish on our Spanish channel for TikTok later in a couple hours. So right now we're just doing an English live, because I understand in some of the Facebook groups, our Facebook groups want some English interaction. And so that's why we are having an English live right now. And then around 12 o'clock, between 12 and 1 o'clock Pacific time is when we'll have our Spanish engagement and our Spanish live for those who only speak Spanish or prefer a live in Spanish. So Elda, I appreciate you being here. If you want to come back in a couple hours, we will be live in a couple hours in Spanish. Okay. Okay. So if you have any questions, concerns versus immigration, I'm more than happy to answer your questions. That's the reason why we are here, is to be able to respond to these questions and respond to any of your concerns that you may have regarding immigration or criminal. We are attorneys also based in California that handle criminal cases. My specialty is cleaning criminal records, particularly for immigrants who maybe have had their constitutional rights violated. And so that's what we are doing. Lucero, I'm fixing to my husband. It's been a few years. How long is the process good for? So, I mean, it kind of depends. So the I-130 right now is taking a year and a half. If you've been in the process, I'm assuming you said you've been in it for a few years. My guess is that you've already done a waiver as well. The waiver is taking 4 years. So, it's quite possible that you're in the process for at least 6 to 7 years. Okay. It's unfortunate, but that's just how it is. And it got longer because of the Trump administration is what caused the delays, and then the pandemic exacerbated those delays. So that's why waivers are now 4 years. I know President Biden tried to reduce the time, but I think with just how many cases, not enough officers, it just wasn't feasible to try to reduce the time. So, but just anticipate that the times are only going to get longer under the new administration, because that's one of his only ways that he could really stop or deter people from applying, is hearing how long it's going to take to accomplish getting their legal status. So don't get discouraged. I know it's a long process, but it's better to start now than ever, because the processes will probably only get longer. They're not. I don't think they're going to get any shorter. The only thing that we saw really short during this administration is adjustments of status for married couples. If you're applying to adjustment of status, we were seeing cases being approved within like 4 months, some of them even within 2 months. And we saw citizenship applications being interviews happening within 4 months, 6 months. And so just the president has the capability to move cases along faster. But they don't, necessarily have the capability to stop them, especially when they're ingrained in the Immigration and Nationality Act, so the INA. Okay, so if you have any questions, please give us a call at 323-553-1541. So one of the other common questions I receive is, what happens if my U.S. citizen spouse no longer wants to help me fix my immigration status? So perhaps you guys are starting to have problems and you started a process and they just don't want to help you anymore. They want to say, sorry, either use it as leverage to help you to get what they want, or they just don't care to help you anymore. And so when that happens, you actually may have relief to fix yourself, to self-petition yourself under VAWA. So under VAWA, it's for people who have been abused or mistreated by their U.S. citizen spouse or resident, children who are over the age of 21 are U.S. citizens. And it's not just physical abuse. Most people associate the Violence Against Women's Act, VAWA, to only be physical, and it's not physical. We've seen abuse happen economically. We've seen sexual abuse. We've seen psychological abuse, verbal abuse. All of that is abuse, is mistreatment, and all that can be used to start a case under VAWA if you have a spouse, for example. So if you have a spouse, for example, you can qualify. If they don't want to help you anymore, most times, or they say they're going to help you and then they don't, and they say, no, I'm only going to help you if you're going to do this. Understand that when they're dangling your status, your ability to have status, in order to get stuff from you, it's because they're controlling you. They want control over you. And so that is psychological abuse, is control. Is controlling somebody, is psychological abuse. And it may not just be that. It may just be that they're, name calling you. I've seen, especially with men who are undocumented and cannot find good jobs to be able to provide for the family. In Latino communities, men are raised to be the breadwinners for the family, to be the providers for the family. And so when they don't, there is, backlash again with the spouse. And I've had several clients who are applying based on emotional and psychological abuse for not having a job, where they're saying that they're not worth anything, that they're not worth they're not a man because they can't provide for their family, that they're worthless. All these things hurt. All these things are a form of abuse. And for those reasons, my clients are able to apply for VAWA and apply for a green card. And so that is something that you would be able to apply if you are going to want to apply for VAWA. That's one of the methods. It doesn't have to be physical. It could be that. It could be physical. It could be verbal or psychological abuse. So if you believe, or you have a family member or a friend who may qualify for VAWA, and this is a status that they will be able to get, please give us a call at 323-553-1541. If you guys are entering for the first time, my name is Attorney Leslie Reyes. I'm an immigration attorney and criminal attorney based out of Southern California. I hope anyone who's in Southern California, you guys are safe, your families are safe, and hopefully you haven't lost any homes. We are based in Orange County, so we're just getting, the smell of it, the smoke of it, but hasn't come out down this way. And so we wanted it, we help anyone throughout the country. Where immigration, we are allowed to work all over the country and represent all over the country. For any criminal case, we can only do in California because I'm only licensed in California. Immigration is federal, so as long as I have a license, I'm able to do federal work on a federal level for any state, regardless of where you guys are at. So if you guys would like a consultation with our office, give us a call at 323-553-1541. Do not forget to also follow us here in our social media platforms, Facebook, YouTube, and TikTok. For TikTok, please make sure you're also following us on YouTube, because we know that the platform may likely be gone by January 19th. And so you want to make sure that you are still here with us and be able to get information regarding immigration, and be able to get information regarding being here on our lives, and be able to answer any questions or have any questions answered for you. So we are going to be here for about 10 more minutes. And so if you have any questions, now is the time to ask your questions regarding immigration. If you have any doubts as to why you maybe want to start a case, or if you should start a case, or any concerns as what's going on with your current case right now, we are more than happy to answer those questions. So another question that I receive a lot is, how do I apply for a T visa? What is a T visa? So T visa is for someone who has suffered and who has been a victim of trafficking, any human or sexual trafficking. So if it, I say human because if you've been trafficked into this country, maybe to work, do something, that's the type of trafficking. Most common trafficking for the people who have been here is labor trafficking. So if you have worked for somebody and they have either provided poor working conditions for you to work, have paid you below minimum wage, do not pay you overtime, do not pay for your breaks, do not give you breaks, maybe depending obviously in your state, they're not giving you breaks when you're supposed to have breaks. They threaten you. Maybe they promise you that they're going to be paying you. Oh, I'll pay you in the future. I'll pay you in the future. Yeah, don't worry. The check is coming. The check is coming. Or they give you a check and it's always bouncing. Or they threaten you if you dare to complain about payments or how anything is being done in the business. And they say, well, I'll call you immigration on you if you have a problem. If you try to leave, they could, say that if you leave, I'll call immigration. Or they could say, I'm doing you a favor by giving you a job. You're undocumented. Where are you going to go? Who's going to give you a job? Like, I'm giving you a job. I'm out of the goodness of my heart. You have a job with us. So why are you going to try to leave? Or threaten, saying that they're going to ensure that no other company will work with them if they decide to leave or not do the work. So all these things encompass a T visa, grounds for asking for a T visa. And on the rare instances, it could be also domestic violence. So if you are suffering domestic violence by somebody, and they require you to either have sex with them in order to get anything done, or they beat you if you don't clean the house, they beat you if you're not working and they don't pay you, all those things can also still equal a T visa. Lucero, I got the I-130 approved a few years back. I was supposed to write my forgiveness letter, but probably haven't gotten to it. Okay, so if you haven't started your waiver, the I-130, it doesn't necessarily expire, but you do have to keep up with immigration with NVC to let them know that, yes, I still want to do this. Give me another year. With that, every year you have to do it. You have to kind of give notification. So, and that's if you did say that they're going to plan to do it abroad. So if you put in your application that you were going to do it here, it doesn't expire if you do it here. But if you did say that they were going to do it abroad, yes, NVC does give timeframes, and they let you know, hey, we haven't heard from you in over a year. We need to hear from you in the next year, or else we're terminating your case. So that's something that you definitely want to look into, Lucero, is to see what's going on. Again, if you're saying you didn't write your letter of forgiveness, my assumption is the waiver. And if you haven't submitted the waiver, it is taking 4 years. We could absolutely help you with that process, but it's really important that we find out what, if your case is even still active with NVC, National Visa Center, because if you said that they were going to go abroad to complete the process, they're going to be the ones who are handling your petition, not USCIS. USCIS, for them, your case has been approved with them, and it's out of their hands with them if you're going abroad, if you're finalizing abroad. So you want to make sure that you contact NVC, National Visa Center, to find out what's going on with that. And if you haven't received anything, state, I have not received anything. Maybe they have an old address, and maybe that's why you haven't received anything. So that's something that you do want to check into to make sure that they are having that information and that your case is up to date or your case is active. If you have any questions, give us a call at 323-553-1541. Now, another question that I receive is, what if my minor child is here with me and they have no, how can I get them status? So if you have a minor here who has no status and your primary concern is giving them status, there's a way to do that. It's under the special immigrant visa status, and that juvenile status, and that is special visa juvenile status, the SIGIS, and that is for anyone who is a minor under 18 years old and has suffered abandonment, abuse, or neglect by one or both parents. So, for example, if you have one parent here in the United States, you want to go file custody, full custody, sole custody in family court, and also ask them to make a SIGIS order. So then that way you can file for the petition. It comes in two parts. In order to file a SIGIS petition, you need a SIGIS order, predicate order. And the only way to get that is in family court or in through a guardianship hearing. Okay, so you need one or two things. So if you are one parent here, there's almost always an argument to say that the other parent who's in your home country neglected or abandoned your kid. And so you can request sole custody of your child here in the United States and request also a SIGIS order so that you can file the SIGIS petition. Once you file the petition, then you can file for a work permit, and then you'll be able to eventually get a green card. If no parents are here, then the minor will need a guardian. And in order to have a guardian, they need a guardian, and you do that in probate court. And the guardian will be assigned to the minor, and they will have to also they would have to demonstrate that they would be responsible, and it could be based on one or both parents. And once they have the order that they are guardians and also the order for the SIGIS order from the guardianship court, then they'll be able to file for the petition and then eventually have a green card. So those are the two avenues that a minor can. Now, for most states, the cutoff is 18 years old. After 18, they will not do a SIGIS order, despite the fact that the SIGIS petition goes up to 21 years of age. Places like here in California, and I think a handful of other states, allow it up to the age of 21. Okay. So it really depends on what state. But most states, it is 18 years old that you have that limit to do for the juvenile visa. And it is a great way for said minor to be able to eventually have a green card. Now, once they have a green card and once they have their citizenship, they cannot then petition for the parents that they got their SIGIS claim for. Okay, so they can't, if they got a SIGIS based on abandonment or neglect by, for example, mom, and then become a citizen, they cannot petition mom. The mother has lost that right. The mother has lost that privilege. It's like giving up your rights. That mother has lost that privilege to be able to have her son petition or her child petition for her. Okay, and so can't do that. So if your purpose is to kind of skirt the law and get your kid to be a U.S. citizen so that they can petition for you, it's not going to work. It's not going to work. Okay. If you have any questions, please give us a call at 323-553-1541. Well, I want to thank everybody for being here with us today. My name is Attorney Leslie Reyes. I'm an immigration and criminal defense attorney, and we are here. We're going to be doing lives in the morning for anyone who wants it in the morning, and then afternoons we do have Spanish. If you would like a Spanish video, we do from TikTok. We do have a different handle for our Spanish videos and our Spanish content. Immigrant for Facebook and YouTube, we are going to be intertwining both of them within within those platforms. Okay, so if you guys have any questions, please let us know at 323-553-15. If you want Spanish, we will be here in Spanish I would say in the next hour and a half. We'll be live in Spanish. So if you have any questions, give us a call at 323-553-1541. If not, we'll see you here tomorrow.